All right, welcome everyone. Tonight we're going to be speaking about estate planning and law essentials. Mr. Skipton Reynolds will be speaking tonight. Skipton has specialized in estate planning law since 2009 and has worked with hundreds of clients to plan their estates, placing an emphasis on protecting the assets of aging loved ones and educating families about complicated laws is his specialty. He advises the best options available to clients and is passionate and helpful in helping others preserve their money, avoiding probate and achieving lifetime estate planning goals. He wants his clients to walk out of his office feeling a sense of relief that their plan was done the way they wanted it to be. He feels an estate plan is a joint endeavor between the attorney and the client. So, all right, we're going to take it away, Skipton.
All right. Well, thank you so much, Chrissy. I really appreciate it. And thank you to everybody that's in attendance tonight or anybody who might see this in the future. But yes, so I'm going to go ahead and share my screen. I've got some slides, so we can kind of go through this. But I'm going to be talking about tonight about what I call the estate planning essentials. And what are those things that we've got to have within our estate plan? So I think that should be showing up on your screen here. And so we'll kind of go through this stuff. If you have questions, please feel free to ask them, either ask them in the chat. Maybe Christy, you can monitor the chat for me. That might be easier if somebody has a
Absolutely.
question.
Sure.
Or you feel free to unmute yourself and ask the question. I want to answer as many questions as I can during our time. And we'll try not to be here till midnight, although I could talk about it that long. So I'm going to talk about these estate planning essentials. Let me kind of get settled here. So kind of agenda, talk a little bit about my background, how I got to where I'm at now. Identify what you want to know. Get ready to ask as we go, right? Your questions are somebody else's. What I found is they're just too afraid to ask the question. So please ask your question. And then we'll talk about how to protect your estate and what that looks like with different tools. So I'm going to make you guys three promises here. And in return, your promise is to ask questions as we go through. So my three promises are that we'll have a little bit of fun talking about death and dying and incompetency and all of that fun stuff, as much fun as one can have. Um, and then you're going to learn something new that you didn't know before. There's an old radio guy that I remember listening to when I was in law school. His name was Paul Harvey. And one of the things that he used to always say was, and that's the rest of the story. We all come here with some understanding of what I'm going to talk about. Maybe we've experienced it. Maybe we've done an estate plan in the past. Maybe had to deal with it because of a loved one passing away or being ill. We all come with some level of knowledge. But what I want to do is I want to give you, as Paul Harvey says, the rest of the story, because sometimes what we take to be the facts might be the facts, generally speaking, but might not be the facts that work for us. And I want to kind of take that apart for all of us. And then lastly, that our time will go fast. So before you know it, it will be 7 o'clock. It'll be time for us to say goodbye. So please ask those questions as we go through if I fulfilled my promises, and I'll ask if I did at the end. So a little bit about me, that's my family. That's my wife, Erin, who actually works for my law firm. She helps our clients if we're doing trusts, making sure that their assets work in conjunction with those trusts. And those are my two boys, Braden in the tan, Cade in the blue. They are a little bit bigger than that. We just took new family pictures last week. So these are from a year ago. So they are 14 and 12. We got 8th grade and 6th graders. I grew up here in Colorado. I'm a native. There's not too many of us around anymore. Or I guess we're breeding more, but not too many originals. A lot of people are from somewhere else. After graduating from high school, I grew up in Southeast Aurora. I graduated from Smoky Hill High School. Then I went away to University of Kansas, where I got my undergraduate degree. I went there to swim. And then after graduating from there, I went on to get my master's and my law degree from the University of Wyoming. It was significantly cheaper than staying here in Colorado. So that's kind of my educational journey. But I like to talk about why I do estate planning. I've had experiences in my life where I've looked back later, maybe you've had similar experiences, and I've said, you know what, something was pulling me in this direction. I didn't recognize it at the time, but I recognize it now. And I feel like my grandmother has put me into what I do now because what happened for my grandparents was my grandparents, had saved, but not saved a lot. They were living in an assisted living. My grandmother had been diagnosed with dementia. And then ultimately, while I was in college, they came to the family and they said, "We can't care for you here anymore. We've got to move her into a nursing home." But my grandparents didn't have a lot of money. And so we had to put her on Medicaid. And Medicaid got her to the end of her life in a nursing home, adequate care. But the problem was our family didn't know what we didn't know. And in this mad scramble to find a place for her to live, she had to move all the way across the Denver metro area away from my grandfather. So my grandparents have been married 65 plus years, and now all of a sudden she's in Wheat Ridge and my grandfather's in Aurora. And he's driving to go visit her almost daily because he wanted to see her and make sure she was being cared for until he passed away at age 93. And what I took away from watching all of this happen, and maybe why I think I do what I do now, is estate planning is about our family. But my family didn't know what they didn't know. They didn't know they need to be thinking 3, 6, 12 months ahead of schedule to make sure that we had more control. So maybe seeing this happen, I now can educate more people so that you make better choices now, so that if and or when the stars don't align the way we all wish, we are more prepared. Our family has more ability to take care of us in the manner that we want to be cared for while we're still here, but also how we want to care for our family when we're not here anymore. Because I think that estate planning is really all about our families. So maybe my grandmother put me here to teach more people so that they'd make better choices for their families. All right, you didn't come here to learn about me, came here to learn about estate planning. So, kind of the goals for me are if you have an estate plan already, like an old will or a trust or powers of attorney, does it meet all of your needs? And if so, then you're what I'll call being all set. I'm going to try to teach you different concepts through stories. I found that significantly easier than the bar exam in law school. And then we'll talk about how to get what's missing so that at the end of your time talking with us or whatever you might decide to do, you are all set. You have what you want and or need for your family. So there's really two sides of estate planning. There's what's going on while we're alive, and there's what's going on after death. And in my experience, I found that a lot of people focus on the after death side, right? Our last will, our beneficiaries, how we own things and potentially trusts. But I can make an argument that the living side is more important than the after death side because we may need to take care of you while you're still alive if you're not as capable as you are right now. And that might be more important than the after death side because you're dead anyway. Things are going to get sorted out. It may not be the way you want. It may be more of a hassle, but you're not here to deal with it. But what if you're still here, right? So how do we take care of you while you're alive? Well, there's really four main documents that take care of us while we're alive. The first one is a financial power of attorney. Sometimes it's referred to as a general power of attorney. This is where you empower someone to take over for you with your financial world. Pay your bills, deal with your bank accounts, your investment accounts, your life insurance, your 401ks and IRAs, your house, your car, everything. But you get to pick who that is. You get to pick what powers they have, what powers they don't have, when they get those powers. You get to pick all of those things. And whenever we're thinking about decision makers, whether it's power of attorney, a last will, a trust, I always like to think in layers. What I mean by that is we need to pick a primary person. Like who's going to step in? If you're married, often it's going to be your spouse. If you're not married, maybe it's your eldest child if they're an adult, or another child if they're adults, or maybe a sibling if you don't have children, or a best friend, or whomever that might be for you, right? But you always got to be thinking in succession plan, where you got to pick a primary person and at least one backup. So my bad analogy for this is, when have you ever seen a football team run out on the field without a starting quarterback and a backup? except for when the Broncos figured it out during COVID, right? And the reason is you've never seen that is because they need somebody to go in there and run the team if the starter gets hurt. The same concept applies here. And if you've got more layers than two, that's even better. With the financial power of attorney, I think when you're thinking about who to name, I think you should be thinking about who's best with money, right? If you've got that person in your life, whether it's a kid or someone else, and they're no good with their own money, don't put them in charge of your money, right? Pick the best person for the job. And I do think that with the financial power of attorney, proximity is not as important these days. You can do pretty much anything online. In fact, I was meeting with some clients this afternoon. They only have one bank account that is a brick and mortar bank, right? They could be living wherever and they could deal with Capital One Bank or wherever. Medical power of attorney. Who's making medical decisions for you in the event you are not capable of making those for yourself, right? This could be doctors working with them. It could be end of life decisions, those kinds of things. Again, thinking in layers, and again, thinking of who's best for that role. Because a worst case scenario decision for you would be they have to decide whether to allow you to keep living or whether to let you pass away. And if they struggle with those type of decisions, I would argue maybe they're not the best person for this role. I do think proximity matters more with the medical power of attorney versus the financial. You know, that they could come and visit you in your home, or if you're not at home in the hospital or at, the senior living community you might be living in. I think it is a little bit more important, but I still do think look at who's best suited for this role, depending on their capabilities. Maybe you have somebody that is, in some way related in the medical field. Maybe they're a good choice, or who's best suited to follow through your wishes. Many of you have heard of HIPAA. You've signed a HIPAA when you go into your doctor, or you go in for a procedure. I call those the vertical HIPAA. What I'm talking about here is what I call the horizontal HIPAA, meaning you're lacking your mental faculties, you're rolling on a gurney or something like that. Who can see that protected medical information? And in our office, and I'm noticing it in many other attorneys' offices, we are now drafting that as a separate standalone document, separate from the medical power of attorney. And part of the reason that we're doing that is people weren't aware that they had this power, and they weren't being told information regarding their loved one because the doctors or the facility didn't know that they had the capability to release all of this HIPAA protected information. It actually happened in my own family where I got a panicked call from my aunt and uncle who lived in Golden. My aunt was calling on behalf of my uncle because she had finally moved him into a nursing home. She couldn't care for him, even with in-home care, with complications from diabetes at the end of his life. But they weren't giving to her his sugar levels in the manner she desired. She wanted to see what they had written down, and they said, "We can only tell you what they are, ma'am." And she didn't like that answer. Well, she had the HIPAA authorization, but it was buried on page 4 of his medical power of attorney. She didn't know it was there. The nursing home didn't know it was there. She didn't know how to overcome it. And I took away from that, how do we make it so she doesn't have to remember where it's at? And so we drafted as a separate document for our family or for our families. Then there's the living will. The real name of this is called the advance directive, but most people know it as the living will. The living will is I'll call it how to pull the plug document. But it is very narrow in its scope. It really only covers 2 scenarios. One scenario is that you are in what we call a terminal condition, meaning that you have an injury or illness that in the doctor's opinion, without life-sustaining procedures, you will die. Or you're deemed to be what we call a vegetative state, meaning that you don't know you're alive, can't move, and you're going to be this way indefinitely without the hope for improvement. It only covers those 2 scenarios. But it is the roadmap to the medical power of attorney of how you want them to make decisions in the event you're in one of those two scenarios. So technically, you don't have to have a living will, but the more you write down, the more information your power of attorney, the rest of your family has as to how you want to be dealt with if you're vegetative or terminal. And you actually have three options of how long you want to be kept alive. One option is once you meet the definition of vegetative or terminal, call it a good life. Second option is plug you in, but only for a period of time. And the thought process there is give time for second opinions, give time for family and friends to come and say goodbye if they choose to, give time for a miracle to happen, but also direction by you of, hey, I don't want to be this way for a really long time. I call it in my office the deep breath moment. It allows your family the deep breath to deal with it in the manner they need to deal with it, with an understanding of what your wishes are regarding a length of time that would be too much for you. Those four documents are the starting point for an estate plan, in my opinion, because I want to make sure that you're taken care of while you're here. But a common misunderstanding I've run into with these things is that a family member will call me post death and say, well, I went into the bank to go get mom's money, but they won't give it to me. I'm the power of attorney. Why won't they give it to me? And the reason is the powers of attorney die when we die. So we pass from the living side of the line to the after death side of the line. And that's when our wills come into play. Our will does nothing until we actually die. It's just waiting, waiting, waiting for that triggering event, which is our death. But also on the after death side of things are our beneficiary designations, right? So if we've got a life insurance policy or a retirement account or any type of account for that matter, you can name a beneficiary on it. But that person that's named as the beneficiary doesn't receive any benefit until you actually pass away. And then if you own something jointly with what we call right of survivorship, often this would be a married couple owning their house or a bank account. If one person dies, the other person automatically owns it. And then technically, trusts are usable on both sides of the line. And I'll talk more about trusts as we go forward here. Because it can technically own assets while we're alive, but it also can deal with our assets in distributing them to our family when we're gone. So those are the essential documents. But now let's talk about who can come after our stuff, right? Who are our predators?
Before
Yeah,
we move on, I do have a question for you.
perfect.
I'm not sure if this is something that's in your purview or not, but you can answer that. What are your thoughts regarding when to engage employment and disability lawyers to prepare for when it's time to initiate the disability option? I've seen people miss this option.
You know, I don't practice in that area, but I would say the time frame to go through that process that I've heard from talking with clients that have applied for these disability benefits, I would say that at a minimum 6 months, maybe even 12 months before you're ready to, call it quits and working. Because what I've heard is not only does it take a long time, you have to potentially, do the application. You may have to provide additional information that they would request along the way. And then in full disclosure, a lot of times they may deny you on your first attempt. I almost feel like this is my tinfoil hat a bit, but I almost feel like they deny you to see how persistent you're going to be. Almost out of principle, they deny a lot of people on the first try. So I think, the best answer that I have, and again, I don't practice in Social Security, law that way, I would say 6 to 12 months minimum.
I think that's a really good answer. I will say we also do have a webinar on our website about Social Security disability law. And so if you would like for me to email you that information, I'm happy to. Just let me know in the chat. Sorry about that. Okay, I'll go away now.
Yeah, perfect. All right. So moving on to who can come after our stuff. Government, long-term care costs, our family, and unfortunately, no one ever sues anybody in the US, right? Or not right. So let's go through the government. So the government can be predatory in a few different ways. Number one is if you don't have the proper documents, those essential documents that I said on the slide here a couple slides ago, we may have to set up a guardianship for you if you're an adult and you don't have a power of attorney and you're lacking capacity, or a conservatorship. So a guardianship is who's in charge of your medical decisions for you if you don't have the power of attorney. A conservatorship is who manages your money if you're alive and you don't have a power of attorney in place. And then in addition to that, if you have minor children, you need to have chosen in your will who would be the guardian of those minor children in the event both parents were deceased or incapable of caring for them. But if you don't take us up on doing the powers of attorney, financial or medical, or doing a will, you lose control. You don't get to pick who's that guardian for your minor children. You don't get to pick who's the guardian for you. You don't get to pick who the conservator is for you. Now, we may have some good ideas, right? Like if you're married, it's probably going to be your spouse. Or if you're not married, maybe it's your oldest child for you. But for the guardianship for your children, it could be a free for all, right? Each side of the family could step up and say, you know what, I'm best suited to be the guardian for these kids. No, I'm best suited. And they fight, fight, fight. And eventually somebody will be appointed, but you don't get a say. Again, why these documents are so important. We want you to have a say. We want you to control these factors ahead of time so that if they become necessary, it's not a guessing game. It's not a fight, right? Probate. Probate is the estate process after death. And really what probate is trying to figure out is two main things. It's trying to figure out who's in control of your estate after you're gone. And it's trying to figure out who are the beneficiaries of your estate after you're gone. If you have a will, you control those factors because you name the executor in the will and you name the beneficiaries. If you do not have a will, the state gives you one. It's your family tree. But you don't control who's in charge of the estate nor who gets it. So, for example, we closed an estate earlier this year of a single woman, never married, no children, only child, died without a will. We had to go all the way up to her grandparents' generation and out to her cousins and second cousins to find a beneficiary or find beneficiaries, excuse me. And two women on her grandmother's side, we had to hire an investigator to go find. These women never actually met the person that died. They'd seen pictures, but they'd never actually met her, and they are getting 50% of her estate because she failed to have a will that controlled those things. So even if you're not getting fancy, and I'll talk about fancy here coming up, it is still vastly important to have a will because in that will, if you have a minor kids, you control the guardianship, but you also control who's in charge of your estate as executor. We actually in Colorado call it personal representative, and you control who the beneficiaries are. And it is the process of empowering somebody to do those things. That's what probate is. And it's filing the paperwork with the court, notifying creditors in a newspaper that you've died. And it's all of these formal processes, but you, at least with a will, control that process. But I'll talk about later how you may be already avoiding probate, but didn't understand the relationship of your will, if you have one, to your assets. And I've got a drawing later that hopefully will make that a little more clear. And then there's taxes, everybody's favorite, right? And I'm going to start with the good news and I'm going to get to the bad news. The good news is every single one of us here in 2024 can die with up to $13.61 million before we owe any estate taxes. And if you're married, you can double that number. So a married couple this year can have over $27 million and owe nothing to the federal government for dying with that amount of money. And it is adjusting up annually. So like last year, it was 12.9. This year, it's 13.61. I'm sure in 2025, it will be over 14 million. But, and this is a big but, we do not know where it's going come 2026. The income tax bill that went into effect in 2018 expires at the end of 2025. And so our personal income taxes and the estate taxes are unknown. Technically, if Congress does nothing, it will reset to 2017 levels plus inflation. Right now, that would be somewhere between 5 and 6 million per person. Still a pretty big number for many of us, but not nearly as big as 13.61. So we'll see what happens moving forward. We're just not sure at this point. We will have to see what Congress does next year. We live here in Colorado. I don't know, is there anybody else that lives outside of Colorado that might be on this call?
I think it's almost all Colorado. We have
Okay,
some Wyoming people, but I don't think anyone is here.
gotcha. So Wyoming, very similar. Colorado and Wyoming do not currently have a state estate tax. So regardless of the value of your money, you are not paying extra for dying here to the state that you live in, Colorado or Wyoming. So that's a good thing. Now, if you own real estate, if you own real estate in another state, be aware that there are still, I think, 9 states that have some form of an estate or inheritance tax. So, for example, we have a client that died owning property up near Ogallala, Nebraska, and we owed 1% of the value of that property to the state of Nebraska. So be aware if you own property in other states or you move to another state, you would want to look into that. We can now this year give away to whomever we want up to $18,000. Many people remember this number being 10,000 or 15,000. In 2024, it is now $18,000 that you can give to anyone. And if you give it to them in the form of what I will call cash, you do not owe any taxes for giving it, nor does the person receiving it owe any taxes as well. If you give away different types of assets, like you handed a stock away and then they sell the stock, they may own capital gains. Or if you give away your house, same thing, they may own capital gains. But if you give it what I'll call a check or cash, they aren't going to owe anything, and you're not going to need to tell the IRS you gave it. So if you got 3 kids, in theory, you could give each one of them $18,000 without telling Uncle Sam. But there's a little known other part of gifting, what I call the lifetime gift exclusion. And way back in 2011, they unified what we can die with what we can give away during our lifetime. So that number, that lifetime gift exclusion this year is $13.61 million. It matches the estate tax. So let me give you an example of how this works. So there's many people that are afraid to give their kid or their grandkid more than that annual 18,000 because they're fearful that they're going to owe gift taxes. But here's how it actually works. Let's just say that my dad gives me $200,000. The first 18,000 this year would count under the annual exclusion. But the remaining balance of 182 is above that. And so what the IRS wants you to do is they want you to file a federal gift tax form saying that my dad gave me 182,000 more. And what they're going to do is they're going to subtract 182,000 from 13.61 million my dad could give away during his lifetime, and they're going to subtract 182,000 from the estate tax allowance. They simply want to track it. So technically, don't do this, right? You could give away your entire estate if you're under the 13.61 million. Now, obviously, you would never do that without good advice from somebody. But in theory, If you don't have that large of an estate, you could give away your entire estate with no federal gift tax consequences. And I'm very intentional when I say that because there may be other taxes, but just not gift taxes. Then comes the really bad news. Most of us are workers where we save our money into retirement accounts like 401ks and 403bs and 457s and TSPs and IRAs. All of that money that is not a Roth has never been taxed. So as we put it in, it's tax deferred. As it grows, it's tax deferred. But at some point, the IRS wants their share of that. And as a part of a law that passed in January or became effective January of 2020 called the Secure Act, our heirs who are not our spouses and don't fall into a couple other categories like a disabled beneficiary or under 10 years younger than us, if they don't fall into these specialized categories, that heir that inherits it, say your kids, will have a maximum of 10 years to pay taxes on all of the money they inherit in that category. And they must take out at least a minimum amount every single year, depending on your age at your death. But all of it must have been taxed within 10 years. They want their cut and they're going to get it. So at some point, we will have to start taking it out if we live long enough, or when we die and we leave it to our non-spouse beneficiaries, unless they fall into those other specialized categories, they will be owing taxes at their income tax rate. So here's how it works. My parents leave me $250,000. If my parents are over the required distribution age for their age, I will be taking out a minimum amount every single year. I can always take more, but at least a minimum amount over 10 years. So if I get 250,000 in theory, if I take out 10% annually, I'm adding that 250,000 to my income taxes and paying at my personal income tax rate. This is why I say this is a big predator for most of us, because that's where a lot of us have put a lot of our savings. And at some point, it's going to get taxed. So in theory, if you are older and you're in a lower income tax bracket than your kids, in theory, you should be paying the taxes if you looked at it from a pure tax perspective. But there's many other things involved. Before you would decide what you want to do with that, I definitely advise you work with either your financial professionals like financial advisors and planners and or your CPA or accountants. But this is a big predator to estates in our office because so many of our clients outside of their house, this is the largest place that they have resources. And the tax man is coming and they don't discriminate. Now, if it's a Roth, you've paid the taxes already, but that 10-year rule still applies. This is a big predator to estates. So I definitely encourage our clients to be working with those financial professionals about how to best do planning for you to have the best overall net effect, not just for you, but also for your children or your estate. But that's a big predator. All right. Long-term care costs, up, and away. Many of you may be aware of these things or not. If you want to stay home in the Denver metro area, just for somebody to come in and cook, clean, and be your friend is the way I like to say it, it is between $35 and $50 an hour. Non-medical. If you are moving into independent living, 2,500 on the low end, 3,500 plus is more normal. If you're moving into assisted living, low end 3,500, more normal 5,000 plus. If you're going into memory care, 7,000 plus. If you're going into the nursing home, anywhere between 8 and 14,000 in the Denver metro area. How are we going to pay for this? Those are big, big numbers. Well, one way is you could go on a program like Medicaid. But have you heard these things about Medicaid? Have you heard that they can take your house? Have you heard that you have to give your assets away, what I call non-take-abackable, meaning giving them away completely? And have you heard that if you give them away, you can't go on Medicaid for the next 5 years, which is 60 months? Medicaid is a complex set of rules and exceptions to those rules. And depending on your scenario, all three of these may be false. But this is what many people think and or know regarding Medicaid. So let's talk about how to protect from long-term care, right? There's really three main ways of paying for long-term care. We can do what we call privately pay. Private pay means you're taking your income, you're taking your assets, and you're paying whatever the rate is that you saw on the slide a couple slides ago. You can have long-term care insurance. The statistics say that less than 10% of people in the United States buy long-term care. Number one reason that you hear is it's too darn expensive, right? Now, I'm an attorney. I like to argue. I could argue that that's faulty thinking, but that is how people make their buying decisions. Depending on your age, depending on your physical capabilities or ailments or other things that you might be going on for you, it may not even be an option. But it is an additional bucket of money if you look into it that can help pay for the long-term care. It may not be designed to cover the whole thing, but it may, if it pays 5,000 of the 8,000, that goes a long ways to extending the life of your other resources. So I definitely encourage folks to consider looking into it. And there's many different options of types of long-term care out there these days. It's not the old days where it was pay, pay, pay. And then if you just keeled over one day, all you did was pay for a peace of mind. There's some different options out there. If anybody on here would like any resources there, we're happy to make referrals. And Parkinson's Association of the Rockies may even have people that specialize in that as well if you want to reach out to them. And then there's Medicaid. You can now get Medicaid to a small degree in your home, or if you're living in the assisted living, there are Medicaid programs, as well as obviously the nursing home. And then if you're a veteran or a surviving spouse of a veteran, depending on financial requirements, service timeframes, et cetera, there is a program called Veterans Aid and Attendance Pension, which is kind of like a thank you, like a long-term care policy, thank you for your service. But Medicaid and these veterans programs all have financial and medical requirements in order to be eligible for them. We can help families qualify for these programs in a crisis within 30 to 60 days. Now, caveat, qualification, them paying. They got to review the application. They may ask for more information. There may be other things involved, but that's how fast we can move things around within an asset structure for a family to try to apply for these benefits. And so I'm actually going to try to teach you a little bit about Medicaid in the next few slides. I'm going to teach you in a crisis scenario and in a pre-planning, meaning we're not sick yet scenario. So we're going to start with Mr. and Mrs. Schmo, and then we're going to talk about the Richards. So in a crisis scenario, meaning somebody is going into care now, here's a potential scenario. So, oops, I got it wrong. It's supposed to say Schmo's, but it says Jones's, right? But here's the Schmo's assets, right? They've got a house, right? We've all seen a lot of equity growth in our house. So they've got $500,000 of equity in their house. They've got a car worth $25,000. They've got cash in the bank of $50,000. Husband in this scenario is ill. The wife is not sick. She's what I'll call well. Her IRA is worth $78,000. They've got other stocks and investments worth $25,000. All of those things are exempt. But let's talk about the qualifying standards for Medicaid, because there's really three for what I'll call long-term care Medicaid. One is medical need, meaning without assistance, you can no longer do 2 out of 6 activities of daily living. These things are getting up out of a chair or out of bed without assistance, needing help going to the bathroom, being incontinent, bathing yourself, dressing yourself, and feeding yourself. If you can no longer do 2 out of 6, that would make you eligible under the medical requirement. The second requirement is income. It is income only of the person trying to go on Medicaid. So obviously, if you're a single person, that's you. If you're a married couple, it's the person trying to go on Medicaid, not the spouse. And the income threshold this year, without exceptions, using exceptions, is $2,829 per month. Oh, shoot. We make 3,200. He makes 3,200. He can't go on Medicaid. Not the right answer. In Colorado, we can use exceptions to the rules where we take that overage and we put it into a Medicaid mandated, what they call income trust. And that we can now get you well above those thresholds. So depending on where you would live in Colorado, that threshold might be different. Like the metro area, you can actually have somebody with income up to $10,888 here in 2024 and still be eligible. If you live in more rural communities, it's going to be a lower number. I think the lowest number in Colorado this year is $8,649. So most people would be eligible. We may just have to jump through some hoops. But then the third one is the one we all focus on, assets. So there are technically 3 exempt assets for a single person or a couple. The first is the primary residence. That's why it's in green. The second is one vehicle of any value. This is where I joke, let's go buy you that fancy car you always wanted, you're never going to drive. Because hopefully it will go up in value versus down. And then the third is where it diverges for a single person versus a couple. For a couple in 2024, they can have a maximum amount of money from any resource, cash in the bank of any type, investments, retirement accounts, cash value and life insurance. They can have no more than $154,140. If you are a single individual, that number is 2,000. So we want you mostly broke if you're a couple, all the way broke if you're a single person. So everything in green for the schmoes is exempt. Everything in red means they have too much. Right? So they've got a $900,000 total estate, but of that estate, the 26, the 11, and the 192 are the overages, right? His cost of care is $7,500 a month. His income's $2,500. Her income's $1,200. We're well within the thresholds, right? The question is, can he go on Medicaid? And the common thought is no. We've got to go spend everything in red till we get down to the 154 level, and then we can apply for Medicaid. So they think that they've got to spend over $200,000 before they can put him on Medicaid at $7,500 a month. But the answer is actually we can put him on Medicaid more quickly. Because there are things that we can do with everything in red to make them effectively stay within the family, but disappear from the balance sheet. And we can put him on Medicaid as fast as we can get those things done. And we can protect everything but the taxes that might be owed on his IRA. Now, we may owe some to Uncle Sam, but let's just say in this example, we had to cash out that IRA and we had to pay them 25% of it. So just call it $50,000 in taxes. Oh my gosh, that's a lot of taxes, right? But if we do the techniques that we can do, we may owe $50,000 to Uncle Sam, but we stop paying $7,500 a month immediately. And they're eligible for Medicaid. So the crossover on that $50,000 of taxes can happen pretty quick, depending on the scenarios. And if this IRA was not his, it was hers, we can protect even more and lose even less to taxes. The point of this slide, from my perspective, is to show you that what we think we have to do to make someone eligible for Medicaid in a crisis scenario is not necessarily the truth. I sit down with people and families all the time, and I go through this and I lay out what are their options so that then they can make a more educated choice of how they want to deal with care for that loved one. Now, caveat, we can protect for a married couple all but the taxes on his IRA in this scenario. If this was a single individual, maybe the numbers are slightly different, we cannot protect potentially 100%. The best that we can do in a crisis scenario is anywhere between 30 and 70%, maybe 80% on the really high side. But we can protect assets. We do not have to go completely broke to have our loved one cared for under Medicaid, which is what most people think. Now, there's some questions on this. Give me 1 second here. Yeah, the long-term care with Parkinson's, that's a hard one. That's a pre-existing, that's a hard one. But there are alternatives. There is one alternative that is not, it is mentally, it has to do with your mental faculties. It's an annuity product. I know about that much about it, but that is something that you may be still eligible even with the Parkinson's. But this is a Medicaid crisis. Well, what if we're not in crisis, right? Maybe we've been diagnosed with Parkinson's or Alzheimer's or something else that may take a little while to fully affect our lives where we would need long-term care. So here is a healthy family, the Richards, right? They got a home, cash, car, and investments, right? If they give their assets away now, how long until somebody could go on Medicaid? And usually the first answer is, well, they can't go on Medicaid at least for 5 years. And the actual answer is they can actually start protecting their assets sooner. So follow along with me. The next slide is about numbers and concepts. Everybody's numbers are going to be different, but it's about the concept here. And then I'll expand upon it in a coming up slide. So if we do nothing, hang on, sorry. If we do nothing with them, it's all at risk, right? Because if Mr. Richards gets sick and Mrs. Richards dies first, all the 577 is at risk. If both of them get sick, all the 577 is potentially at risk. But what we can do is we can utilize asset protection trusts, and I'll talk more about these coming up, where we can protect potentially all of this 577 within a 5-year time frame. And what we do is we put these assets in a place where you can control them, but Medicaid can't come and get them at a later date. And so I'll use this Richards example when I get to talking about trusts here in just a few minutes. All right. But the point of this is you can start sooner. Even if you have a diagnosis of Parkinson's, we can start now to start taking assets off what I call the balance sheet so that we don't have to go into crisis mode like the schmoes if we don't want to or need to. But then there's our family. Our family can actually be our predator, right? Our spouse can be a predator to our estate. So this is what I call the dollar story, right? Let's pretend that a couple has $2, right? It could be 200,000, it could be 2 million. If one spouse dies, typically they want the other spouse to get all of their share, right? Well, I'll use myself as the example. If I die and I leave all the money to my wife, what can she do with the money? The answer is whatever she wants. It's all hers, right? Well, that could include putting in the pool that she's been begging for in the backyard, but I've told her no, right? I didn't want to pay for it. I didn't want to maintain it. So she puts it in when I'm gone. But she didn't want to do those things. So she hires Biff the pool boy. And Biff takes care of the pool and takes care of my wife. And now she can spend that money with Biff in any way that she wants. Cruises around the world. Maybe they get married. She dies first because he's a younger man, right? And then now Biff has that money. And it may not trickle down to my children, right? And I have no say. I call that an accidental on purpose disinheritance. Accidental by me and my wife, on purpose by Biff. Or maybe my wife dies and I go meet, Bambi the barmaid because I'm drowning my sorrows over losing my wife. But even our spouse can change the plan after our death. Now, you may or may not be worried about that, but that's a question I've often seen most people have not even thought about. But then there's another one, and this may be real for this group. What if the spouse who may need the long-term care is not the first to die? Right? I call it dying in the wrong order. If I die and leave all the money to my wife and she's got Parkinson's or dementia or something similar, now all of our money is at risk to her long-term care needs. Well, what if we don't like Biff and Bambi? What if we don't like that long-term care scenario? What can we do different? We can, with a will or a trust, take that dollar of mine and set it aside for my wife. She can still use it, but she can't give it to Biff the pool boy. If she falls ill, it can be protected in what I'll call a special or a supplemental needs trust, so that not all of our estate is at risk to her long-term care if she needs it. And not all of our estate is at risk to Biff the pool boy, so that it still goes to my ultimate beneficiaries, my children. That may or may not be an issue for your family, but it's often, again, something I have seen most people haven't thought a whole lot about. But then there's our kids or our other beneficiaries if we don't have them. They're always good with money in our eyes, right? Or not. Maybe they're a spendthrift. Maybe they have bankruptcy issues or addictive behavior, or they are disabled or become disabled. Or what if they get divorced? So I call this the condo story, right? So I inherit money from my parents and I go buy a condo in the mountains. And I put my wife's name on it and she meets Skip the ski bum. And she likes that Skip better than this one. Well, when we get divorced, she's going to get half of that thing because I put her name on it. Well, I live here in Colorado. We're what we call a separate property state. I don't have to put her name on it. But do you think she knows I have it? Do you think she knows that we short-term rental it? Absolutely. And she's going to ask for more in child support. She's going to ask for more in alimony, and she's going to ask for more of our own marital estate. And she is more than likely going to get all three. And she may even get a portion of the growth of the value of that condo. Because if we've been married long enough, she may be privy to that as well. Or what if I don't get divorced and I'm an adult child and I die? Where's my money going to go if I'm married? It's going to go to my wife to go find my replacement with my parents' money. Or a lot of times our grandkids are about the time we're getting around to dying, our grandkids are going to college. If I inherit a bunch of money, my kids are going to college, they may not get that scholarship or that grant or that financial aid because now I've got more money on my balance sheet. We can, through your will or through your trust, protect from these scenarios if you want. And if you've got minor children, oftentimes like myself, I want to control who controls the money for them. When the kid gets more access or control, or what it's used for or not used for in the future. We can control those things if we want. And then lawsuits, right? If I die in the car accident because my wife's driving and then I leave her all the money and it's her fault and she injured somebody else really bad and they make a large claim, our assets could be at risk. Or if my parents die and leave me money and I get sued for some reason because I'm a business owner or a car accident, all of those assets can be at risk. unless we try to protect them in our wills or our trusts. Do you have to do any of these things? The answer is absolutely not. But again, what I found is so many folks have never asked themselves these questions. I feel like part of our attorney job is to ask you the hard questions, regardless of what your answer is, so that we get you to the plan that's right for you. So that's our family. But how do we protect from our family? How do we protect from long-term care? How do we protect from these things? Well, we can do it with the right type of trust. There are trusts that we can create out of our last will and testament. We call that a testamentary trust. In order to create these, though, we've got to take your estate through probate.
This would be good for you.
Or we could potentially have a living trust. There are two distinct types of living trust. There are what we call revocable living trusts, or RLT for short, or irrevocable trusts. But there are three parties or three parts to every living trust. And those three parties are, number one, who formed the trust? We call them the grantor. That is often you. The second party, who are the trustees of the trust, meaning in control over the assets within it. And the third party is who are the beneficiaries of that trust during your lifetime and or after your death. In a revocable living trust, I like to analogize it to this radio flyer red wagon in the corner, where you are the one who created the wagon. You are the one pulling the handle of the wagon as trustee and in control. And you are the beneficiary of the contents of the wagon. So you can decide what goes in and what goes out at any time. A common misconception of a revocable trust, though, is if you've got a revocable trust, your assets are protected from your creditors. That is not correct. If you can go and access your assets, so too can your creditors. A revocable trust does not protect you from Medicaid. A revocable trust does not protect you from the lawsuit. But a revocable trust can start protecting from Biff or Bambi when you die. It can start protecting from your kids and they're being young and setting up a rule book for them, or their remarriage or their divorce or their bankruptcy or addictive behavior. But all of the protections in a revocable trust come after death. But it can avoid probate because I can put the title of your house in your trust. And now I've avoided the probate issue. I can name your trust as the beneficiary, and now I've avoided the probate issue. And I'll show you in a couple slides what I mean. But a revocable trust does not actively protect your assets while you are alive. If you want to protect them, you must give up something. And that something is direct access to your assets. If you can directly access those assets, the bad guys can as well. So what we use in the Richard story is this one with the spigot, where you can create the trust, you remain in control over the trust, and you are not the beneficiary. The beneficiary out of the spigot is your family, your children, typically if you have them. But when you do this, you start the 5-year clock ticking for protection of the assets within the trust. But we never, ever, ever put all of your assets in there. Number one, you don't want to ask somebody else to do things with your assets, right? Spend your money, take the trip, whatever. So the low-lying fruit for so many of our clients that we're trying to take a big asset off the balance sheet and get rid of a whole bunch of what ifs is your real estate. When or if we sit down and talk, I will walk you through what that means, because there are definite positives to this, but there are definite negatives. And I want to be fully disclosing to you what those are for you in your personal scenario. But this is how we proactively start protecting if a family wants to do it. We've got to give up direct access, but we do not have to give up control to start protecting. All right. So you created your rule book. Are you done with all of your planning? The answer is no. Hang on one second here. My headphone's about to run out of speaker. I'm going to switch. Can you guys still hear me? Perfect. All right. Sorry, I had to switch audio there. So you create your rule book. You create the protections from Biff, Bambi, condo story, maybe young children, whatever you want. But that's only step one of your plan, right? So step one is creating that will or trust. But step two is integrating all of that in, all of your assets with whatever you put in writing. And then you got to maintain it over time, whether it's the documents or the integration of the assets. And if you don't do all three, your plan will not work out exactly the way you want. It will become ineffective. This is an ongoing process. Too many of our clients do their estate plan, put it in the safe place, and don't look at it for years. This is something that you don't have to look at necessarily every year, but you do need to keep on top. So you've got the rule book, right? Are you all set? No, you got to integrate it. So if you create the radio flyer red wagon, the revocable trust, or any kind of document for that matter, you have to make sure that it works. So if I'm worried about Biff the pool boy and I own a joint account with my wife and I die, she owns it, not subject to my plan. If I name her as the beneficiary, not subject to my plan. It may avoid probate, but if it doesn't get to the plan, we may not be able to create the protections you were looking for. But we can very easily avoid probate. Here's what I mean in illustrative form. How do we set up these beneficiaries? Right? So again, if you're married and you own something jointly, it will go automatically to our spouse. If you're not married or you don't have joint ownership, maybe it goes to your kids or other by naming them as beneficiary on these documents or these different accounts. Or maybe it's the contingent beneficiary is the kids or other if you don't have children. And in Colorado, you can actually do what's called the transfer on death, or it's referred often in my circle as a beneficiary deed with your real estate. You can technically avoid probate in Colorado without the use of a trust, simply by designating a beneficiary on everything: bank accounts, investments, retirement, house, car. And it is what I have called in our office the here you go plan, right? If you're married, one of us dies, it goes to the spouse. When both of us die, it goes directly to the kids. But it does nothing to plan for those minor beneficiaries that are too young to receive the assets and you want to create a rule book. It does nothing to protect it from your spouse remarrying or having long-term care issues or the condo story like I talked about earlier. It is simply a handout. If you want to create protections, we got to send the arrow either to your will and through probate to create the protections, or often we use a revocable trust to create the protections post-death. But the trust can avoid probate by owning assets or being designated as a beneficiary. You've got to integrate your assets appropriate to whatever your plan may be. And if you don't, you may have unwanted or unnecessary probates. You may have things not following through your plan in the way that you desire. This is a big piece of estate planning. It's not just the documents. All right. So the goals of the workshop are, does your current plan meet all your goals? And if it does, then you're all set. I taught you through the story and I talked about how to get what's missing, but that was the easy part. But before I move on, did our time go fast? I'm seeing it's been just slightly over an hour. Did we learn something that maybe we didn't know? As Paul Harvey says, the rest of the story. And I don't know whether you were laughing or not because I couldn't get the feedback on this medium, but hopefully you laughed about Biff and Bambi and Skip the Ski Bum and some of the other stories that I told through here. But here's how we identify what's missing for you. You can choose to protect your stuff in 3 easy steps. And you can do that by calling or requesting
a meeting with me. We call it a vision meeting, where we're going to assess your needs, talk about creating what's missing, and tying in a plan and integrating it together if you choose. We give you a discount for attending this workshop or watching it online and being a part of the Parkinson's Association of the Rockies. On that, it is half price of what we normally charge for a consultation. What that makes it is it makes it $175. But that $175, if you needed us to help you with anything, would credit towards any planning that we would do for you. So it is not on top. It is simply to make sure that we are engaging with you in the way that you want. And in that vision meeting, if you have documents, make sure that we have the chance to review them. You will be meeting with me. And I'll assess what you want versus what you have and or what you need. And I'll provide you options to create what's missing to get you where you want or need to go. You will not be paying big numbers unless you choose to hire us, right? This meeting is simply to help you assess where you're at and what you may need in the future. And if you'd like to request that, and there's no obligation, right? This can be purely for your education that you're here this evening. Our contact information is here on the slide. That's our main office number. And then you can email at that info number, or you can go to our website. And there's all kinds of resources on our website. I've got all kinds of YouTubes breaking down these subject areas that I hit on quickly this evening. We've got breakdowns of those in more succinct categories, and you can go and listen to that content. You can request a meeting from there if you'd like as well. Before I set you free, are there big questions that anybody has? I see one here. What do I think of using an online will creator? So, biased opinion, have to preface it this way. There are lots of resources out there on the internet. One of the issues that I see with internet-made wills, powers of attorney, trusts, is that we don't know what we don't know. And we think we've got it covered, but we may not. One of the big issues I see is execution of the documents, meaning signing. Did you have it notarized and witnessed appropriately? Did you know what you put into that document, what you needed or wanted in true form, right? Many of us think that we're very, very simple, and we may be. But that's where an attorney, I think, earns some of their money, is we're asking those hard questions. I had a client years ago that he came in and said, I want it easy, easy, easy. And I asked him the Biff and Bambi question as he's sitting next to his wife, who's 15 years his junior. And his physical demeanor changed. He realized it wasn't that way for him. So I struggle with the not knowing what you don't know piece of it. I think the other thing that I've seen in my office is people buy that online stuff and then never complete it because they start digging in and they don't know what to do and they stop and then they don't do it at all. Susie Orman is a big contributor to this issue. I mean, she does great things. People buy her packages and then they start digging in and they go, whoa, I don't know what to do. But there are online resources. And in fact, we have an online resource where you can actually go onto our website, and at the bottom of the main page, there is a link where you can do a very simple estate plan, but I review it. So it's not the same as going to, say, some of these other online resources, because I go on the backside and I say, oops, you missed something here. Is that on purpose or not? Kind of a thing. So, I'm not totally against them. It's better than a stick in the eye. Obviously, biased opinion. I think you should talk with an attorney, whether it's us or somebody else. Oh, good question. In-person meeting or a Zoom meeting? We can do either. We meet people where they're at. Technically, the only meeting that is helpful to have in person, if possible, is the execution of the documents meeting, just because then we can do all the copies and scans and everything, and we can move the paper around for you. But I even have clients all throughout the state of Colorado that I've mailed them documents with instructions of how to fill them out and done everything via Zoom. Any other questions anyone has?
Feel free to unmute yourself and ask it live if you prefer. Sounds like you covered everything.
But hopefully, and if you have questions, feel free. You can use that info at Skipton Law to ask more questions, or you can get a hold of the Parkinson's Association and they can funnel it to us as well. We want to answer those questions. Like I said, I'm really passionate about being a resource on this stuff because of family experiences.
Yeah, we're happy to help connect you guys to Skip if you prefer. Feel free to email me. Everybody has my email address that registered for the event, and I'm happy to share information with Skip about those who've registered if you'd like to receive a discount. Thank you so much for being here. I really appreciate you all, and I hope you have a great evening.
Thank you, everybody.
Thank
And
you,
thank you so
Skipton. We
much,
really
Christy.
appreciate you.
Appreciate it. Have a great night.
You too. Bye-bye.